Hello, this is Sudeep Kumar Dwivedi, Assistant Professor of Law from Gemtech School of Law, Greater Noida. The topic for today's lecture is petition under section 482 of the Code of the Criminal Procedure under the subject drafting, pleading and conveyancing. First of all, we will try to learn what is section 482. Then our focus will be on the drafting part of the petition under section 482 of the Code of the Criminal Procedure. As we know, section 482 of the Code of the Criminal Procedure 1973 provides that saving of inherent power of the High Court, nothing in this code shall be deemed to limit or affect the inherent power of the High Court to make such order as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court or otherwise to secure the end of the justice. So, the code gives to the High Court various power, including those relating to the reference revision and all. It also recognizes the inherent power of the High Court to prevent the abuse of the process of any court or to secure the end of the justice. So section 482 preserves the inherent power of the High Court to prevent abuse of the process and to achieve the end of the justice. The provision does not confer new power, rather it only recognizes and preserves the power which inhere in the High Court. Means the power is already vested with the High Court. The section just recognizes that power. The invocation of the jurisdiction of the High Court to quash the FIR or a criminal proceeding on the ground that a settlement has been arrived at between the offender and the victim is not the same as the invocation of jurisdiction for the purpose of compounding an offense. While compounding an offense, the power of the court is governed by the provision of section 320 of the Code of the Criminal Procedure. The power to quash under section 482 is attracted even if the offense is non-compoundable. So while we were discussing the compoundable offense, we discussed that there is two category of the offenses. One is where there is no permission is required, and another is where the permission of the court is required. And the third category is that where of the category of the offenses is that where there will be no compounding of the offenses. However, since the High Court has been given some inherent power to achieve the end of the justice or to stop the abuse of the process, that's why in some certain circumstances the High Court may exercise this power and allow the compounding of the offenses even in the non-compoundable offenses. Here I have taken the example of the first information report, questioning of the first information report. Generally, if in some offense an FIR has been registered and that offense is not compoundable as per section 320, in that case if there has been a settlement has been arranged, then in that case the parties may approach to the High Court under section 482 for the questioning of the FIR, because we know that since the if that offense is not compoundable, then there is no other provision regarding the compounding of the offenses in the matter regarding non-compoundable offense. However, we have discussed that the High Court is having inherent power to achieve the end of the justice. That's why if the parties are agreed, in that case they may approach the High Court under section 482 of the Code of the Criminal Procedure. While the inherent power of the High Court has a wide ambit and plenitude, it has to be exercised, as we discussed, to secure the end of the justice and to prevent an abuse of the process of any court. So we have already discussed that these two criteria on the basis of which the high court should take decision whether the court should exercise the inherent power or not. The decision as to whether a complaint or first information report should be quashed on the ground that the offender and the victim have settled the dispute revolves ultimately on the facts and circumstances of each case, and no exhaustive elaboration of the principle can be formulated. So we know that the fact and circumstances of each and every case may be different. So it cannot be said that there will be this there will be a formula that if this is existing, then the court should proceed for the questioning of the FIR. That's why there it cannot be or it is not possible to give a principle or a formulated formula on which the court should exercise. That's why it is known as the inherent power. You can say where the court has to see each and every case that whether end of the justice will be achieved or not, abuse of the process is there or not. That's why 482 has been created. Now let's see what will be the structure. It will start like that. In the High Court of Delhi at New Delhi, extraordinary criminal jurisdiction, criminal miscellaneous main application number so and so. Then the party in the matter of detail of the party, that is the petitioner, then versus and city of Delhi and another respondent. After that, an index will be attached with the petition, and this index will include notice of motion, urgent application if it is urgent, memo of parties, criminal miscellaneous main petition for questioning the FIR number so and so section, police station under section 482 Crpc along with an affidavit. After that, there will be an annexure, that is the copy of the FIR. Then there will be another annexure copy of the compromise deed, and then another annexure copy of demand draft, and next annexure will be the affidavit of the respondent, and then application for exemption from filing certified copies of the annexure along with the affidavit, and then in last there will be wakalatnama, is the sign of the petitioner through advocate. The complete detail of the advocate should be there, then the place, date and sign. After that, it will start like that. In the High Court of Delhi at New Delhi, start any criminal jurisdiction, criminal miscellaneous application number, then again the detail of the parties, and then there will be notice of motion. It will be start like this: sir, the enclosed petition in the aforesaid matter is being filed on behalf of the petitioner and is likely to be listed on so and so date or any date. Thereafter, please take notice accordingly, issue an appropriate order for quashing and setting aside the FIR number so and so, petitioner through advocate. There will be sign on the notice of motion. After that, it will start again in the High Court of Delhi at New Delhi, extraordinary criminal jurisdiction number. Again, the application miscellaneous maintenance petition number, application number, then the detail of the parties will be again there. Then the main part will start: criminal miscellaneous application petition for quashing of FIR number so and so dated so and so under so and so section of IPC, then police station and Delhi and the state under section 482 of CRPC. It will be in a bold heading. After that, it is most respectfully submitted as under that the petitioner number 1 is a so and so, and the petitioner number 2 is working as a manager of the petitioner number concern. So first of all, that the detail of the petitioner, what is his position, and then the detail of the petitioner number 2 and what is his position must be mentioned. that the respondent number 2 is the deceased late detail of that person, and that the deceased was then how the things happened. It will be mentioned that the deceased was working as in the factory of prisoner number 1 and was drawing a monthly salary of so and so per month. That on so and so that the deceased unfortunately died in an accident while working in the factory of the prisoner number 1. That an FIR was registered under at so and so police station on so and so date under section 285 304A of the IPC in connection with the death of the deceased. Then the detail of the deceased should be written. Then copy of the said FIR is enclosed and marked as annexure number P1. Then there will be next para that subsequently the parties executed a compromise deed dated so and so, wherein it has been mutually agreed and settled between the parties that neither the petitioner nor any other person was responsible for the death of the deceased, which took place by way of an accident under extremely unfortunate circumstances. A copy of the memorandum of the settlement is enclosed as annexure number 2. Then the next para will be that it has been settled between the parties that the aforesaid compromise deed, the prisoner number 1 has agreed to pay so and so rupees inwards also it will be written by way of pay order dated. Copy of the aforesaid pay order is enclosed as marked as annexure number 3. Then there will be next para that as per the memorandum of the settlement executed between the parties, there is no claim or dispute whatsoever pending between the respondent as against the petitioner. As per the settlement deed, the FIR number so and the allegation made by the respondent in the FIR stand withdrawn, and the respondent shall make a formal statement for questioning of the aforesaid FIR before this honorable court. A copy of the affidavit of respondent number 2 is enclosed and marked as annexure 4. After that, the next para will be that in view of the amicable settlement between the parties and present petition is being filed for questioning of the aforesaid FIR, then that the present petition is being filed on the inter alia the following amongst other grounds. Then there will be a ground clause. The first ground will be that for that the petitioner and the respondent number 2 have amicably settled the matter wide memorandum of the settlement dated so and so date, whereby the respondent has agreed to the questioning of the aforesaid FIR number so and so. That FIR and is now no useful purpose, is having no useful purpose. It would be in the interest of the justice that the said FIR is quashed. That for that it has been settled between the parties that the death of was a cause due to the accident and that no one was responsible for the same. For that, in an event on a reading of the FIR as it is, no offence whatsoever is made out against the petitioner, including the offences under section 287, 336, 304A of the IPC, then that this honorable court has the jurisdiction to entertain and adjudicate the instant petition. Then the next para will be that this petition is being filed within a reasonable time and there is no delay in the same. The next para will be that no other petition for questioning the FIR has been filed by the petitioner before this honorable court or any other court of law. That the aforesaid facts and grounds constitute the cause of action for filing the present petition. Then in last there will be a prayer clause. In view of the aforesaid, it is most respectfully prayed that this honorable court may be pleased to quash the FIR number so and so under section 287, 336, 304 Indian Penal Code and police station listed so and so place, and pass any other order as may be deemed fit and proper in fact and circumstances of the case. Then there will be sign of the petitioners, and then if it is through advocate, then sign of the advocate. That's all about the petition under section 482. Here I have taken the example of questioning of the FIR which has been filed against the accident which had taken place in the petitioner factory, and by if they have reached on the amicable settlement, that's why they approach the court under section 482 for the quashing of the FIR because it was not compoundable even with the permission of the court. That's why they approach the court under section 482, which is inherent power, and that is which is having aim the end of the justice and to stop the abuse of the process. And in this case, if the court had allowed the proceeding, even if there was settlement between the parties, then it would have been a waste of time of the court and of the victim. That's why in such type of matters court generally allow the quashing of the FIR under section 482 of the Code of the Criminal Procedure Code 1973. That's all. Thank you.